No, they're back. They're back. Yeah, I picked my wife up at Logan. Her flight got in at 8, but then it takes an hour.
Okay, the board is going to reconvene now in open session at,
Are we on?
we're on 7:35.
Dick Van Dyke. 7 what?
7:36.
7:26?
That's what I said.
Okay, 26, okay.
Okay, well, we have no acceptance of minutes tonight, no appointment, resignation, public comments, nothing around town, so the chair will open the public hearing at 7:27. It's continued from August 22nd, 2016, to discuss notice of intent, right of first refusal on the Corbin Road, consisting of 55 acres, more or less, Book 52337, page 94. Owner Annabelle Meninsky, under the provision of MGL, Chapter 61A, Section 14, as it relates to the Islamic Society of Greater Worcester versus Zoning Board of Appeals lawsuit. Is there anyone here tonight who has any more information, new information, would like to discuss anything else here tonight for the public hearing? Okay. So I guess we'll go ahead and move to close the public hearing if there's no new
You
information.
have to hear from...
Actually, Mr. Chairman, if you would hear a report from the town administrator, and I think you've
Do
requested...
you want to go ahead and do that in the public hearing?
In the public hearing, yes. So that's
Okay.
part of the public record of this hearing.
Okay. Mr. Belluconis, then.
Good afternoon or good evening, board members, residents of Dudley. The chairman asked me to report on the possible purchase of the land on Corbin Road for municipal purposes. And as part of that process, I received written responses from the fire chief, police chief, and highway superintendent about whether their respective departments were interested in using the Corbin Road property in the event that it's purchased by the town. In each case, the town officials either had no interest or could foresee no legitimate need for the property going forward. In addition, I contacted the superintendent of schools about whether the land might be suitable for a future school site, and his response to me indicated that in all likelihood, any future expansion, if necessary, would take place on land already under the ownership of the school department. I next reviewed various land use and planning reports in the possession of the town that address preservation of property in Dudley, and I couldn't find any references to the Corbin Road land whatsoever, let alone the land being listed as a priority for preservation of farmland. The documents and the reports that I read include land use priority plan and the Central 13 prioritization project, both prepared by the Central Mass Regional Planning Commission with significant impact from Dudley officials. I also had an opportunity to review the Dudley reconnaissance plan, which similarly found no references to the Corbin Road land or it being listed as a preservation priority relating to the town's long-term planning for open space in our community. I also reviewed how Dudley compares to other Massachusetts communities under the Agricultural Preservation Restriction Program, or is being referred to as the APR program, which is intended to preserve farmland. As a result of it, I discovered that a total of 28.4%, or 4,005 acres of land in Dudley are dedicated to conservation status, including APR and Chapter 61A parcels. Dudley is one of only a handful of communities with a large number of APR properties, and is the only one that I could find in central Massachusetts with over 16 properties participating in the program. The Corbin Road land also does not appear to be suitable for farming if the front portion of the site is dedicated for other uses. The rear portion of the property has a high groundwater table, making it largely unsuitable for farming, as previously stated in a report to the Board of Selectmen from discussions with the Dudley farmer. The 55 acres of land is listed for sale at $287,000, which is the amount the town would pay if it were to complete the purchase. The most recent assessed valuation of the property is $199,800, or 44% lower than the purchase price contained in the purchase and sale agreement provided to the town on July 1st of 2016. It is typical that properties valued by the town's assessors have a plus or minus range of about 10%. However, in this instance, the proposed purchase price varies greatly from what I consider to be the accepted range which one might see acquiring property for municipal purposes. And finally, there was considerable discussion during the public meetings and public hearings about the land being used as a municipal water source. The water commissioners had previously reported to the Board of Selectmen that the land was abandoned as a potential water source in the early 1990s after a feasibility study was conducted and radon was discovered during the water quality tests. The land remains abandoned by the commissioners to this day as a result of the high cost of remediating the contamination, and there are no plans to reestablish it as a municipal water supply at this time and into the future.
Okay, Mr. Valiakonis. Town Council, Mr. Brackett.
Yes, Mr. Chairman, members of the board, just briefly, I'd like to just review the chronology of the 61A process in this matter to try to address some of the questions that have been raised, not only in the public meetings, but and members of the press about the correlation between the Chapter 61A issue and the zoning board proceedings. The zoning board proceedings began on or about January 7th when Ms. Meninsky, the property owner, and the Islamic Society of Greater Worcester inquired of the building inspector that they wanted to propose a cemetery on this 55-acre parcel of land. The building inspector indicated that that would require a special permit in a residential 87 zone. And the reason I mention that, and I think it's important for the public record, is the town of Dudley allows a cemetery on that parcel in that zone, subject to an applicant meeting the special permit criteria. So the applicant was given that information from the building inspector. The applicant filed the application on the same day. Now, when I spoke with Ms. Meninsky sometime in March, it was her understanding back in January, when they signed the purchase and sale agreement, that the 61A issue was going to be addressed by her representatives. That was her understanding. But the application for special permit was filed with the zoning board. The 61A notice of intent, right of first refusal, was not filed with the Board of Selectmen. So there was a delay in that. While the zoning board hearings were continuing, the notice of intent proceedings were stalled because we cannot act under the statute until we receive a notice of intent. We didn't receive a notice of intent until June 14th. And we have 30 days to file what's called a counter notice. And a counter notice is to list the defects in the notice of intent of the statutory requirements under 61A, Section 14. All of those have to be included within the notice of intent. So when I went through the notice of intent, after Greg sent it to me, I noted the defects. I sent the counter notice to Attorney Tom Brousseau. Mr. Brousseau responded on July 1st with an amended notice of intent, including the 3 categories of information that were missing in the first submission. So we didn't have the notice of intent, compliance with the statute, until July 1, 2016. In my experience, Mr. Chairman, if a party is seeking zoning relief before a zoning board and everybody knows that there's a 61A issue, the responsibility is on the owner and the proposed purchaser to address the 61A issue to the town manager and the Board of Selectmen in a timely fashion. And several attempts were made to try to reach out to Attorney Tallerman and to Attorney Brousseau and Ms. Meninsky. I prepared a letter for Mr. Valiakonis, which he sent to her at her residence in Maine. We then followed up by my making a phone call to her in Maine, asking, 1, did she receive the letter? 2, did she plan to respond? And she said Attorney Brousseau was working on the matter. So at least we knew it was in process. And, Mr. Chairman, I can tell you, I'm sure Mr. Valiakonis can echo this, at no time did we hear from Mr. Brousseau that he was not going to file the 61A notice of intent for Ms. Meninsky. It was in process. However, as I indicated, we didn't receive it until June. We didn't receive the corrected one until July. So that has held up this entire process. Had the notice of intent been submitted in a timely fashion, on or about January 7th or sometime thereafter, at the same time the PNS agreement was signed, at the same time the application for special permit was signed, this process would have been over and done with before the zoning board had to take action on the special permit, because the 120 days would have run from the time of filing of a fully compliant 61A notice. So I just want to explain that, because to the extent that information is important not only for this board but for the citizens of Dudley and any citizens who've been following this matter in the state and elsewhere, that the zoning board was dealing not only with the application for special permit, but was dealing with the failure of the property owner and the applicant to address and deal with the notice of intent. So the situation that exists before you, and if I can briefly summarize, Mass General laws have several provisions that relate to a municipality's right to acquire property. And the primary issues, as addressed by Mr. Balakonis, are, number one, what is the municipal purpose to acquire the private property? And if so, what is the proposed purchase price? Is there a bona fide offer in the purchase and sale agreement? And that definition is included in Chapter 61A, Section 14. The purpose of the public hearing under the statute is to allow for this board to receive input from the public, from the town administrator, from departments, from any other representative of the community, including Ms. Meninsky and her attorney, and the Islamic Society and their attorney. And I would just make note, Mr. Chairman, just from my legal observations as town council during these proceedings, Ms. Meninsky and her attorney, Brousseau, have not participated in these hearings. And the Islamic Society, through their representatives, as the potential purchaser of the land, and their attorney, Talaman, have not participated in these proceedings. They have not come before you as part of the public record and objected to the 61A notice or in any form, whether it's legal for us to begin to require the 61A notice, or even if it's legal, whether there's a valid purpose to acquire it, and even if there's a valid purpose, are we overpaying at the price of $287,000? The points made by Mr. Balakonis in his report. So you haven't heard from them. You've obviously heard from members of the public. Mr. Balakonis has provided you with departmental reports from his department heads' meetings, including, I know he sent me a copy of a report from the school department. And if I recall correctly, Greg, the school department said we have plenty of surplus land, that we don't need this site. If we needed to expand or build a school somewhere, we would be using our other land for that purpose. So all of that being said, we come back to the basic elements. Under Chapter 40, Section 3, it gives the general power of the town of Dudley, just as every other community, 351 communities in the state, to acquire and hold property. Chapter 40, Section 14 provides the funding mechanism. We need a vote of town meeting, even if we're accepting a gift of land. But if we're buying land, we need a 2/3 vote for an appropriation. If we're acquiring land by eminent domain, the legislature has addressed that in Chapter 40, Section 50. And we have the power to acquire land for eminent domain for a public purpose. But clearly, we have to have a public purpose, whether it's acquiring under 40, Section 3, 40, Section 14, 40, Section 15, because in order for this board to go before town meeting and ask for a 2/3 appropriation, the obvious question is, what do we need the land for? And there's another section under Chapter 40, Section 15A. If a town department no longer has need of a certain parcel of property, that town department, let's assume the school department, let's assume the DPW or police department, you build a new police station has no need for an old location. That board can notify the town administrator that we no longer need that property, so that municipal purpose for which the land was originally acquired no longer exists at that location. In that instance, under Chapter 40, Section 15A, once the department declares the property surplus, the town meeting can vote, two-thirds vote, to transfer the care, custody, and control from one town department to another. But that is a decision of the town meeting. And that's obviously, once again, to emphasize the importance of, number one, identifying the public purpose when you acquire the land, maintaining that public purpose during the time you hold the land, and then if there's going to be a change in the public purpose from one department to another, that's the realm of the town meeting. Another thing I'll just mention briefly, so you sort of not just understand the overall scope of the issues that Mr. Balakonis has addressed. Chapter 30B is what's called the Uniform Procurement Statute, and Section 16 of Chapter 30B, which the statute has been in effect since 1990. And at the time it was adopted, I was one of the municipal attorneys who participated in training programs around the state to train local procurement officers on the impact of buying goods and supplies, professional services, acquiring real estate or disposing of real estate. And one of the requirements under 30B-16 to acquire what's called a unique acquisition is you can avoid the bid requirements under that if you have a public purpose that can only be served by a particular property. And if you establish that you have that particular purpose at that location, and nowhere else in town can satisfy that, if you put it out to bid, no matter how many bidders you got, 10, 15, 20, you need that site because of its proximity to a source of water for a water treatment plant or something of that sort. So you would have to identify not only the public purpose, but the reasons for the unique acquisition there. Now, I want to make it clear, this is not a 30B matter, but this is intended to show you why the issues Mr. Balakonis has addressed are so important. The public purpose for the acquisition of the property, and then the expense for the acquisition of the property. So when we consider under the circumstances, and Mr. Balakonis has shared these reports with me, in my opinion as town council, having served this town for 24 years as town council and having served as a public attorney a little longer than that, in my opinion, there has not been established during this public hearing a public purpose for the acquisition of this land. You don't have any town department that has said to you, we need this, for example, agricultural preservation. We need it for open space conservation. We need it for active or passive recreation. We need it for water protection as part of a master plan for water resources for the next 10, 15, 20, 100 years. And you have none of that documentation here from the town administrator's report, and therefore I would suggest that there's an absence of a public purpose before you, and that you would be within your rights to vote to waive your right of first refusal. The second part of that is, even if a public purpose had been proposed, which it has not, you would still have the ability to balance the public purpose versus the cost. And if this property is just too expensive for the acquisition for a particular purpose, that you understand you can get the same type of land on in another part of town for half that money or a third of that money, whatever the case may be, then clearly that's part of your fiduciary responsibility as selectmen. You're the chief elected officials in the town to determine if this price is too high for that, we can find somewhere else to take care of our need. But in this case, Mr. Chairman, you have no demonstrated need, and you have a purchase price which, as Mr. Balakonis has spoken, would seem to be excessive for this. So with all of that information, I'll just repeat my opinion that you do not have a sufficient public purpose established for this, for which you could take a vote to exercise the right of first refusal, because if we were to fast forward to the floor of town meeting with an article to acquire the land, if you have no record of a public purpose in this proceeding, these 4 or 5 public hearings you've had, then technically, if a group of 10 citizens, if they wanted to challenge the appropriation, as being an illegal appropriation. They have a statutory right to file just such an action and establish before a judge that this is an illegal appropriation of funds because there's no public purpose for the property. So in the same way you might hear from people who might want you to acquire the land to hold it in reserve for some future public purpose, you may have just as many, if not more, citizens out there. And I can tell you, I've been at town meetings where selectmen go into a town meeting and they seek authorization. They want to acquire the land for the purpose. They have a public purpose. They think the price is right, and town meeting votes no. Or town meeting doesn't give the selectmen a two-thirds vote required. So the article fails for lack of a two-thirds majority. So we don't have those circumstances here. We haven't gotten over the first hurdle. We are here at this level. I'd be happy to answer any questions that you have. And I'll just finish on this point. There's been some question raised about whether or not we had a legal right to pursue the 61A issue. I feel confident. I've spoken with Mr. Davis, spoken with Mr. Balakonis. I've spoken with other attorneys around the state for whom I have a professional respect. And I can tell you that a couple of months back, I was sitting at my computer, and I happened to notice that Attorney Talaman posted a question on the Mass Municipal Lawyers Association listserv. Does a town have a right of first refusal when the sale of agricultural land is for a cemetery and not for residential, commercial, or industrial purposes? And when you post that, municipal attorneys around the state, both those who practice before boards and commissions, but also those who represent cities and towns, such as Mr. Talaman representing the town of Douglas, have a right to weigh in. My review of the answers, I just sat back and watched the answers coming in. My review of the answers was that more attorneys around the state agreed with our position than with his position that 61A wasn't necessary. And the unfortunate thing about this, Mr. Chairman, if that matter had been presented, as I said earlier, and I don't mean to be repetitive, but the reason I say it's unfortunate is because that has delayed this process unnecessarily. If that notice of intent had just been presented at that time, and if we had a public hearing in February rather than starting in July, Mr. Talaman could have sat at the table and said, oh, it's been submitted by Ms. Moninsky, but we don't think as the Islamic Society you have a right to consider it. Right, well then put your position on the table, part of the record, we'll consider it. If you have anything new to show us, let us see it. If Attorney Brousseau, whom I've known from all the time I've practiced in Dudley, if he feels that he's submitting the notice of intent under protest, he doesn't want to do it because he doesn't think it's necessary. Even though his client told me in a phone conversation she was under the impression this was being dealt with back in January. So I'm not trying to indicate anything by that. In her mind, she knew very well that this was 61A property. She knew very well that she'd been receiving preferential tax treatment on these 55 acres during that whole time it was held in 61A. So she was at least aware of the 61A responsibility. Had that been submitted in a timely fashion, the zoning board hearings could have proceeded, the Board of Selectmen hearings could have proceeded, you could have rendered your decision. If, with the record we have today, if your decision, based upon the recommendation of Mr. Balakonis and myself, is not to exercise the right to acquire the property, that decision could have been rendered before the May 23rd, 2016 town meeting. Town meeting could have been advised of that. Mr. Balakonis put that article on as a place saver. In the event we got the notice of intent before the town meeting. The sad thing about this is that because Mr. Talaman kept fighting the issue of complying with 61A, we had to go to town meeting. We didn't even have a price for the property. And as you know, the town moderator said, ladies and gentlemen of town meeting, you cannot act on this article because they don't have a P&S agreement, they don't have a price. All you can do is vote what's called a sense of the meeting vote to authorize the selectmen to acquire the land, which, as the moderator correctly pointed out, you already have the right to do. You don't need a town meeting vote to authorize you to have these hearings. It's a statutory process. This is the first step. If you say, yes, we want to acquire it, you go to town meeting as the next step. And if you decide to request a Prop 2.5 override, you then go to the ballot box as the third step, as Mr. Balakonis put in that article. He had all the bases covered in the article. What we were missing was a P&S agreement and a notice of intent. So, Mr. Chairman, I think, as you know, and I'll certainly let John speak to the litigation, but I gave an opinion to the zoning board that in my experience, that the failure to comply with 61A by the owner in conjunction with the applicant, an issue they knew about from day one, starting on January 7th, the failure to comply cast a cloud on their rights to the property. My former partner, Elaine Lucas, with whom I started my firm in 1993, argued a case before the appeals court involving Bill Ricca. The holding in that case was the town's right to acquire the property would exist even if the property was transferred. So had Ms. Moninsky gone ahead in January and transferred the property outright to the Islamic Society, and then the Islamic Society came in seeking relief, and then we discovered it was a 61A parcel, we would have said, whoa, wait a minute. You can't transfer it until you give us notice and a right of first refusal. And the appeals court agreed with her. So even if the property is sold, we have a right to go in and invalidate that sale if we have the public purpose involved. So I appreciate, thank you for the time, Mr. Chairman. I didn't mean to go on, but I wanted you to know there's a rich history of statutes that relate to the town's power to acquire and hold property. 61A is one of those elements. The interesting thing about 61A is when a 61A property is put before you, you have a right of first refusal regarding that specific property. You don't have to go through a unique acquisition that you would under generally a 30B acquisition, which means a 30B, if you need property and it's worth over $25,000, you have to put out an invitation, a request for proposals. You have to detail all your requirements, and you have to give everybody in town an opportunity to respond. And only if it's a unique acquisition can you bypass that. But here, if there's a uniqueness to this parcel, and there's a municipal purpose to this parcel, you have the authority under 61A to follow this, I would suggest, fast-track procedure. All of which, as I suggested, Mr. Chairman, it's a shame we've had to go through this and for these hearings to essentially to be clouded by pending litigation. But that being the case, that's my recommendation. Please let me know if I can answer any questions.
Thank you.
Thank you.
Anything from Attorney Davis? You all set?
Mr. Chairman, just very briefly, I came late to this process, as you know, but my understanding was that the Board of Selectmen had received a compliant notice of intent from Ms. Moninsky after the original one that needed some further supplementation. But upon receipt of a compliant notice of intent, it was incumbent upon this body to review that particular notice. I think it's this body's responsibility when agricultural land is being transferred to take a look at that purchase based upon the fact that this is land that has enjoyed the benefits of 61A for years. So if the town has a right of first refusal, I think it's incumbent upon this body to look into it. And that's my understanding of the process that has been followed since July 1, that this body has held 4 or 5 hearings with public input, including tonight's hearing with the input from Mr. Balakonis that he developed in solicitation and participation with the department heads. And so you now have the information. I think it's all part of your due diligence. I think that that's what you are supposed to do when agricultural land is being transferred. And so with that information and with the input of town council, it's now up to you, and I think Attorney Brackett has correctly articulated the things you have to look at. Is there indeed a public purpose? And if there is a public purpose, I don't even know if you get to the second step, but if there is a public purpose, is the price acceptable to the town? Is it in the best interests of the town to go forward and exercise that right. So now I think that my understanding, if this body is prepared to close the public hearing, you now have to make those decisions, whether or not this is in the best interests of the town to exercise the right of first refusal or choose not to exercise the right of first refusal.
Mr. Joseph?
I have nothing else to say in terms of public hearing. If you just declare the public hearing closed, fine. I mean, I didn't make up my mind until talking with the attorneys tonight. But aside from that, as far as the public hearing goes, I have nothing new to add.
Okay. Mr. Fox? All set, Mr. Valiakonis?
You need a motion to close the public hearing.
Yes. Mr. Chairman, if I can just ask, Mr. Balakonis, I know that attached to tonight's agenda, you have your 61A documents.
I do.
Can we, do we understand that all of those documents plus your report are part of the public record?
Yes, they
They
are.
are. Okay. So with that, Mr. Chairman, I think it would be appropriate to, you can accept a motion to close the public hearing, and then you can deliberate here in open session on the issues of public purpose, the price involved, and certainly Mr. Balakonis, Mr. Davis, and I are allowed to answer questions for you during deliberation, but your public hearing portion will be closed.
Okay. Before we do that, are any last-minute questions based for our attorneys or based on what our attorneys for the town have stated?
Well, I guess one of our big concerns is...
Have it come forward, please.
Could you come up so we can use the microphone?
Lynn Sclagian, Corbin Road, Dudley. One of our biggest concerns that has been all along is the matter of the high water table on that property. And I understand that you don't feel that that property is suitable for public use and not eligible according to your rules in acquiring the property for the town. I understand that. But on the position of us abutters who have our wells that are right there, where all the water leaches down from that property, who's going to go and protect our wells? Who's going to protect our health? When it comes to the roads, we have very, very narrow winding roads there. So now the property, if it's not going to be acquired, and they decide to go ahead and put in the cemetery, who's going to be responsible to upgrade the infrastructure, to widen the roads, to narrow?
Is it your feeling that the only way to protect the wells is to purchase the land?
My feeling to protect the wells is to have somebody pay attention to what's going to happen if there's a leaching problem and all of our wells are affected by.
Stop me if I'm wrong.
Go ahead, Mr. Joseph.
The issue of protecting all those private wells and the issue of the water table is something that will have to be considered by the Board of Health once the public hearings resume on this request.
Correct.
Absolutely positive. That's not going to go unaddressed.
If I may, with respect to the ZBA process, the ZBA issued its decision based solely upon the fact that this 61A issue is still pending. If this board were to exercise the town's rights with respect to 61A, that right would be superior to, by statute, would be superior to the right of the prospective purchaser, the Islamic cemetery. So by this board, if this board should vote not to exercise that right, under the decision issued by the ZBA, they said they would welcome the applicant back to resume the pending proceedings, and I would suspect that that's where that process would then have to be resumed. With respect to the water, the Board of Health has, I think, very vocally several times has said that they are going to look into that, but they need the applicant to return to the Board of Health process. So under Chapter 114, they will have the applicant will have to return to the Board of Health, and there will be a public hearing process where those issues, specifically those issues with respect to groundwater and surface water runoff, are within the bailiwick of the Board of Health. They will address those there.
Mr. Chairman, if I
so-
might just add one point to that. In addition to Mr. Davis's comments, you're probably aware from these hearings that there could be as many as 5 approvals. If the selectmen take a vote not to exercise the right of first refusal, there could be as many as 5 approvals. Those are the zoning board, and that relates to the use of the property. And as I mentioned earlier, the town has already said a cemetery is allowed by special permit in that zone. So the zoning board has to review the application for special permit based on 2 criteria in the zoning bylaw. And now that the 61A issue may be resolved at this level based on this public hearing, if the zoning board renders a decision to allow the cemetery in some form, I mean, I don't know if you've attended all the hearings, but,
Yeah.
okay, then I think you've heard that during the course of the hearings, you know, the density of the cemetery, the size of the cemetery, it's been discussed, you know, at various levels. So it will go back to the zoning board. If the zoning board renders a decision, the zoning board decision can include a condition. This approval for special permit is conditional upon Board of Health approval, as Mr. Davis said, under 11434. And then one of the reasons the applicant gave, Mr. Chairman, for not going back to the Board of Health after the February meeting, well, originally, they didn't go back. There was a February meeting. Jen Canoyer drew up a letter she asked me to review, asking the Islamic Society to provide a listing of information for the March meeting, March 15th. The material was supposed to be submitted on March 11th, Friday, so the Board of Health members could get the material, review it before the 15th. The material was never submitted. On the 14th, the Islamic Society asked for a continuance. So they appeared in February at the first meeting. They didn't appear in March. They requested a continuance of the April meeting, and then in May, they requested another continuance generally because they said, we want to continue this generally until it's determined what the size of the cemetery is going to be as approved by the zoning board. So rather than the Board of Health dealing with a 16-acre or 12.4 or whatever the case may be, basically what the Islamic Society said was, please give us some time to work out the size of the cemetery with the zoning board, and then we'll be back to you because then we'll have the dimensions of the cemetery fixed. And beyond that, there's a possible approval by the Conservation Commission if there's any impact to buffer zones for wetlands. It's been acknowledged that there may be a requirements for site plan approval, Mr. Chairman, for any on-site parking. Roger Dubois mentioned that during a zoning board meeting, saying you may need site plan approval, check with the building inspector. And then the last approval that we've raised is a requirement for town meeting approval under Chapter 114, Section 34. And that's based on a 1925 Supreme Judicial Court decision, highest court in the state, that from our research, and John has looked at as well as I have, has never been overturned. So we have those 5 levels, and each group has a specialized area of jurisdiction. They are all, and I'll use this term, they're all considered to be municipal regulatory bodies. When they grant an approval, if they grant an approval, they can grant it with reasonable conditions to address concerns such as you and any of the neighbors.
So I do understand that regarding the Board of Health and the water table issues, but I guess one of the things that I want to ask is who's going to address the matter of our roads? I mean, have you been down Corbin Road? Have you gone down Hayden Pond Road? The routes that you have to take to get to these cemeteries, it's very narrow roads. Some of our roads are only 14 feet wide. Right in front of the cemetery, there was a fatal head-on crash because you cannot see over the top of that knoll when you're coming either direction. So my concern is not just, you know, the water table and my wells being contaminated. It's the safety of myself, my neighbors, you know, the kids that are out there riding the bikes, the mothers that are out there trying to walk their children. You know, who's going to address the issue of the infrastructure of the road? Because the way they are, they're most definitely going to have to be widened, repaved, and whose cost is that going to be?
So I think all of those concerns are precisely the concerns of this board as well. But, stop me, this vote tonight and this discussion tonight does not address any of those concerns. This is an entirely separate matter that we're voting on tonight. Those concerns have not been adequately addressed. as far as we're concerned. And that process is in a state of, what's the appropriate word?
Well, if, as I said, if this body should vote not to exercise its 61A rights, I will report that to the court. And we have a case management conference next Tuesday. And the court may very well, at that point in time, suggest that this matter be remanded to the ZBA, where many of those concerns can be addressed. So there's further steps in the process, as Attorney Brackett said. There are further steps in this process, and various departments have various issues that they are supposed to look at. And this body looks at the issue of 61A.
And I do understand that.
And Mr. Chairman, I could just, for the individual's information and the board's, if the matter is remanded back to the zoning board for consideration of the cemetery, as you know, and I'll state for the record in this hearing, that on June 2nd, with the representatives of the Islamic Society there, we were aware, Mr. Balakonis and I were aware of the settlement that had been reached between the Islamic Society and the neighborhood at approximately 4.9 acres of actual cemetery land, maybe a total of, I think it was parcels A and B on the original plan. So rather than 6 parcels on the original plan, it was down to 2 parcels. That could have been presented to the zoning board with a reopened public hearing, but the Islamic Society would not agree to reopen the public hearing, which to this day, I think Mr. Davis and I both, I think, are somewhat befuddled by their position, because had the public hearing been reopened, we could have then heard the proposed settlement. We could then have had more time to hear your comments on a possible reduced cemetery. What does a 5-acre cemetery do in terms of traffic on Corbin Road? And, Mr. Chairman, the Selectmen, as a Board of Public Works, if I'm trying to recall, also serve as a Board of Public Works and supervise the Department of Public Works. You have an interest in the public ways in town. But when it comes to the question of whether the zoning board can impose that as a condition on, let's say, for example, a 5 to 6 acre cemetery, the question would be how much of the traffic on Corbin Road is going to be generated by the cemetery, how much of it is generated by recently built subdivisions or residential areas, whether there's any industry in the area. So it's not an easy fit, and that's something that the zoning board would have to consider. And I only say this to you not to create any undue expectation that the imposition of a requirement regarding road widening, any suggestion that that would be imposed on a cemetery that is suggesting only 9 to 15 burials a year based on their testimony, is something that would have to be weighed, because we don't want to consider approving a cemetery but then imposing a condition that might be deemed to be unreasonable, because it's a burden that should be shared by the residents in that area or the town. Is that a town responsibility versus the Islamic Society responsibility? That's the kind of balancing we have to do in evaluating that. So once again, that testimony would be most appropriate to the zoning board at a remand hearing.
And I do understand that they did state it would be 9 to 10 burials per year. I also am quite aware that the cemetery in Enfield, Connecticut is 80% full right now, and once it is full to capacity, we will be the centralized largest cemetery, Islamic cemetery in Massachusetts and the surrounding states. So are they going to hold to their position of stating they're only going to do 9 to 10 burials a year and turn away other Islamic societies from having burials in that cemetery? Once the permit is gained to have a cemetery, fully online, who's going to hold them to that? So yes, 9 to 10 burials a year on Corbin Road in a small 5-acre cemetery, I agree with you, would not be a huge impact. But they haven't submitted that. They've stood by their original plan.
Mr. Joseph.
Let me remind you that they have never answered the question asked publicly, do you intend to turn this into a regional cemetery? That's number one. Number two, they have repeatedly, on numerous occasions, in public, said that they were willing to ask only for what they needed and nothing more. We're cognizant of the things that they have said, and I would expect that they are also. And I'm not about to support the town being on the hook for massive, all by itself, for massive road work on any bucolic back road, country road, anywhere in the town. So, we're aware of that, believe me.
That's all I have to say. Thank you, sirs.
Thank you.
Thanks. Thank you.
Mary Sansucci, I live on Ramshorn Road here in Dudley. You're all aware of what the water table is there, that there were 9 holes dug, and the best was at 30 inches, the worst being at 18 inches, mostly at 24. Do you have any idea what it would take, excuse me, to have what they call in the trade, a 5-foot lift on that property? Meaning bringing in 5 feet of material so that you have adequate space between the water table and the bottom of the grave?
Right, so as part of that would be, if we got back to that process, that would be certainly a question that may end up in the Conservation Committee's lap. But we're very much aware of that water table.
And Dudley also has a prohibited use bylaw where you cannot move material, whether it be sand, loam, gravel, whatever you want to call it, within 6 feet of the water table on the property where the land is, the material is to be moved from.
Yeah, if I recall, we had 13 outstanding unanswered questions from the Board of Health alone before this process ended, so we're very much in tune with all of that.
And the other concern I have, and I understand where you're all coming from tonight, disappointed, but I understand. I don't mean to be critical, but the process to me seemed very convoluted from the beginning. There never seemed to be any understanding of what came first, what came second, what came third, in terms of the ZBA, the Board of Health, the Conservation, and especially the DEP. And I think that should be addressed, and I think there should be a body in this town that says, if you want to build a cemetery, then you must first apply to the DEP. And then the board, maybe the Board of Health should be the last on the list, but then Conservation and ZBA and so on and so forth. I think that would help enormously.
Can you speak to that, Mr. Brackett?
I can, Mr. Chairman. Frankly, Ms. Sansucci, I know how committed you've been to this whole process and your attendance at all these meetings over a period of time. I think you've probably been present when we've asked those questions of the applicant. Mr. Balakonis and I were trying to avoid an issue with the 61A matter.
Right.
That should have been dealt with.
Right.
Anyone owning 61A land, as I've heard from attorneys around the state, the first thing they do when that land's being converted to non-agricultural use is they give a notice of intent. If they want to argue they're not required to give it, they come to the hearing and say, we gave it to you as a courtesy, we don't have to give it, but we're doing this to move the process along. So, and we had the issue early on about the agricultural preservation restriction.
Exactly.
Which, as you know, Mr. Balakonis and I both spoke. I spoke with a woman by the name of Tara Zita.
She's the attorney.
Right, at the Department of Agriculture.
Right.
And John LeBeau, who is the Commissioner of Agriculture,
Right.
is a former town administrator in Princeton with whom I worked as town council. And he also was a former selectman in Shrewsbury, so he understands the municipal level of these things. And they looked at it and they said that because the mortgage foreclosure, the mortgage on which the foreclosure was based, predated the agricultural preservation restriction, that we could not enforce the APR. I reported that to Mr. Balakonis and the zoning board. I did ask them for a written letter, but Ms. Zeta apparently was not able to get back to me. But her word was enough to me that we didn't have an enforceable APR. So
I asked her myself to quote the law that said a foreclosure wipes out what their people, Craig Rykoff, wrote on page 6, that it carries with the deed to all owners.
right, but my understanding, and I did speak to a conveyancing specialist in my own building about the priority of these types of liens.
Yep.
And the mortgage, because it went on record before the APR, had priority. So when Ms. Meninsky foreclosed on the mortgage, that wiped out the APR. And I can just tell you, I talked to Ms. Zeta. She said, this is pretty straightforward. If you have any questions, talk to a conveyancing specialist, which I did. I'm not a conveyancing specialist, so I did turn to somebody and got that information. But I think, just getting back to your original point, we started, the building inspector gave his opinion on January 7th. They needed a special permit.
Right,
They started with the zoning board.
right.
They also decided to simultaneously, or in a parallel track, go to the Board of Health. But then when they saw what the Board of Health was looking for, those 11 or 13 items,
They never responded.
they
Balked.
have not responded to this day
Right.
to that request for information that was based on a site visit with members of the neighborhood, I think, were there were engineers there. They've never responded to that, to even allow the Board of Health to be working on the larger cemetery proposal before we heard on May 20th that there was a settlement with the neighbors on the smaller proposal, the 5-acre proposal.
But when you say a settlement with the neighbors,
Yes.
who are you referring to?
I'm referring, I think Mr. Perrin was quoted in the newspaper.
Mr. Perrin lives way over on Baker Pond Road.
Well,
He isn't even close.
Well, what I'm saying is, Mr. Perrin spoke at the meeting one night and said he invited representatives of the Islamic Society to come to his home to talk about this issue. They apologized because they hadn't returned his 2 calls. My understanding around May 20th, as it was reported by, I'm not sure if Debbie LaPlaca was the author of that story.
The May 20th article in Telegram Gazette, where you quoted Mr. Benazzi? Right.
Yes.
That he mailed an offer to the gentleman who hosted the meeting.
Right.
And the gentleman did confirm that he had received that he is in a proposal from the society.
And that was a proposal, I think, that was conveyed to Mr. Balakonis.
It was given to me, and I photocopied it, and had every reason to believe it would be presented at the ZBA meeting. And we all know that it was not.
Right, they chose not to.
Right, I
So-
had the plan all ready to go, and
Exactly.
it never got
But
presented.
none of the neighbors were ever invited to those meetings or meeting at Mr. Perrin's house. I'd like that to be on the record.
All right, but I think, in all fairness to Mr. Perrin, who I know is not here tonight, he announced at this zoning board meeting, it might have been the March meeting, I don't think it was the April meeting, he announced that he invited them to his home.
For dinner.
So frankly, I'm assuming that if there are any neighbors who were interested in that, they would have contacted Mr. Perrin and said, I'd like to be part of that process. It's, I've seen that in my experience where neighbors and an applicant get together and try and figure out if they can work out some issues, if they can work out half their issues, but they still have to debate over half the issues before the board, at least they've reduced the scope of the dispute. So all I'm saying is, I'm not suggesting he has a right to speak for everyone in the neighborhood, but he was very open and upfront about his willingness to host them. And apparently, as a result of that meeting, it was reported in the press, and if I recall, John has probably read these more recently than I have, there was an editorial the next day sort of applauding the settlement. So on June 2nd, the next CBA meeting after May 20th, I simply asked the Islamic Society, are you going to make a presentation to us? We need to reopen the public hearing to hear what's been reported in the paper. And they said no. And June 9th, there was no change between June 2nd and June 9th. And we were running out of time on June 9th because the zoning board has to act within 90 days of the close of the public hearing in April. And that deadline was July 2nd. We had members of the zoning board whose term was expiring on June 30th, such as Mr. Du Bois and Mr. Canty,
Right.
who chose not to extend their terms. So we didn't have any more time, but even when I asked them to grant an extension of the 90-day period, On the last proposal we had before us, which was 12 acres, they said no.
Mary's perception is not unique. There's a lot of people, certainly who have spoken to me, and I'm sure, I would assume to other selectmen, about how convoluted and bizarre the process was. And I just want to be sure that folks understand, and I want to make sure I'm saying this right, that the convoluted process is not what the town had in place, but it became convoluted due to actions and inactions by the Islamic Society and their attorney. That's where the convolution came in. Is that a fair statement to say?
I think that's a fair statement, because
Because she's not the only one that feels that way, believe me. There's a lot of people that are confused by
early
this whole
on, I
thing.
asked many, many people, what is the process? Where do you start and where do you finish? And what comes in between? And nobody could give me an answer. And I think that's huge.
okay. But with all due respect, Ms. Sansucci, you and I have been in a lot of these public hearings. I don't recall you ever coming up to me after a meeting and asking me, could you please just help clarify what is the process?
You're right, I never did ask you.
You never did.
I probably
And
should have.
as you probably saw, there were people who did approach me after the ZBA meetings in February, March, and April to ask questions. So all I'm suggesting is I would have been more than happy to try to address any misunderstanding that existed there, because, as I said earlier, if they filed the notice of intent in January, that process would have been over and done before the zoning board closed its public hearing.
Yeah.
Right.
And then we would have known by May 23rd, either we're going to town meeting or we're not going to town.
Right, and I remember on that notice of intent, I was distressed that the process had begun, the hearing process had begun without receiving the notice of intent. However, I believed that no such notice actually existed. There was no signed purchase and sale agreement. It wasn't until I read an article in the Boston Globe by Brian McQuarrie back on March 30th that I realized that there actually was a signed purchase and sale agreement.
Really?
To that time, we had no knowledge. We may have suspected, but we had no knowledge. It was actually a signed purchase and sale agreement, and it was disclosed as a result of a newspaper story. And I immediately contacted Gary, I remember, after reading that, and said, you know, this kind of changes everything. So we went from February, all of February, to the very last day next to the end of March before we even had acknowledgement that that document existed.
That's interesting.
Thank you.
Okay, is there a,
I thank you.
okay.
Thank you. I do have one more quick question.
Yes, ma'am.
How, and it's for the attorneys, I guess. I obviously know what the vote is going to be tonight. I think I know. How will this vote affect the proceedings in land court? Or maybe I should rephrase that and say the outcome.
Okay. I mean, I can't predict necessarily, but this,
Right.
this certainly lifts a bar or an obstacle to the plaintiff's case in the land court. The plaintiff has said that one of the things the judge ought to determine is whether or not the town has a right of first refusal under 61A. If the body should vote tonight not to exercise that right, then that issue is moot. And I would suggest to the judge that there's no reason that the judge needs to decide that. Another issue that they have raised before the land court is the appeal they are taking from the ZBA. They think that decision was in error. And again, I would suggest to the judge in the land court that because that appeal, that decision by the ZBA was based upon this right that had not yet been exercised, it's now, the path has been cleared for the applicant to return to the ZBA. So my suggestion to the land court judge would be remand this case back to the ZBA for further proceedings, and further proceedings in front of the Board of Health with respect to the water issues, and let this work its way through the process that the town has in place.
Okay.
And I can't predict how the judge will rule on that. And, you know, I'm sure Attorney Talaman will have some response to our position. But again, because the 61A issue was wrapped up into that case, it's incumbent upon me to advise the judge next Tuesday of the vote of this body.
Okay. Thank you.
And I will do that.
Thank you.
And the other thing, Mr. Chairman, just to note briefly, that the litigation in the land court also involves a claim by the Islamic Society against Ms. Meninsky, allegedly claiming that by Ms. Meninsky filing the notice of intent through Attorney Brusso, that somehow or other is interfering, and maybe we are interfering. I can't recall, John, whether there's a count against us.
There's both.
As well, a count against us as well as a count against Ms. Meninsky for interference with contractual relations. Well, frankly, that's a head scratcher as well, because if Ms. Meninsky filed a notice of intent pursuant to the statute, but now Attorney Tallerman is suggesting that somehow or other she violated the purchase and sale agreement by doing that, that's something he should have sorted out back at the time they sat at the table to discuss the P&S agreement. And that would have simply been, Ms. Meninsky, you filed for the 61A, we'll take care of the application for special permit. There's our division of responsibilities here going forward. It wasn't done.
Bizarre.
And, Mr. Chairman, we're not talking about, we're talking ABCs of zoning and land use practice here. We're not talking about, rocket science.
May not have had a camera crew.
It's got to close the hearing?
Yes, I'm going to look for a motion to close the hearing.
You don't need it, you can close it
I
yourself.
want you, I was advised by counsel that we're going to have
Want a motion to close the hearing?
Yes.
Okay. Mr. Chairman, I'm going to move that we close the public hearing at 8:28 p.m.
Second.
Motion by Mr. Joseph, seconded by Mr. Fox. Any discussion? Hearing none, all in favor?
Aye.
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 Okay, we'll declare that hearing closed. Next, we'll, let's have a motion on the vote. Mr. Fox.
Mr. Chairman, I'll make a motion that we waive the right of first refusal to purchase the land on Corbin Road.
Motion to waive the right of first refusal to purchase the land on Corbin Road, made by Mr. Fox,
Second.
seconded by Mr. Joseph. Is there discussion on the motion?
Just one question. Town Councilor, is there anything else, any other wording that should be added to that motion?
No, I
No.
think that's complete.
Okay,
That's fine.
thank you.
Hearing none, seeing none, no one wanting to be recognized for discussion, we'll call it to a vote. All in favor?
Aye.
Opposed? It's a unanimous vote.
So that's declared a unanimous 4-0 vote?
4-0 vote. What I'd like to do is take 5 minutes and then move right to agenda item number 11.
Number what?
11. 5-minute recess.
Yeah,
I'm okay. I'm not. I teach you guys how to hold your water.
yeah.
I know.
Jonathan, you have anything?
Anything from the TNG?
Deb? Any questions you want to ask as part of the...
Okay,
Okay.
thank you. I'll accept the motion to...
So moved that we adjourn.
Second.
Seconded, all in favor.
Aye.
Good night.
Hi, everybody.